Good day, ma'am. My report is about Section 4, Factors of Granting Continuance. The following factors, among others, shall be considered by a court in determining whether to grant a continuance under Section 3 of this rule. This section provides guidance to court on factors to consider when deciding whether to grant a continuance under a specific rule. It highlights that certain considerations beyond those listed may also influence the decision-making process. A. Whether or not the failure to grant a continuance in the proceeding would likely make a continuation of such proceeding impossible or result in a miscarriage of justice. This factor highlights the critical importance of assessing whether denying or continuance could lead to either the inability to continue the proceeding or an unfair outcome, termed a miscarriage of justice. It underscores the need for courts to prioritize procedural fairness and integrity of legal proceeding when considering requests for continuance. That's all.
Good day. I'm Matthew Sarep Chua, and now I'm going to discuss Section 4, Factors for Granting Continuance, under Subsection B, whether or not the case taken as a whole is so novel, unusual, and complex due to the number of accused or the nature of the prosecution, or that it is unreasonable to expect adequate preparation within the periods of time established therein. In addition, no continuance under Section 3 of this rule shall be granted because on congestion of the court's calendar or lack of diligent preparation or failure to obtain available witnesses on the part of the prosecution. Section 10, Circular number 38 to 98. So, in subsection B, the passage introduces the second factor, which involved evaluating the overall complexity of the case. Factor contributing to complexity might include the novelty, unusualness, or complexity of the case due to the number of accused individuals involved or the nature of the prosecution. It suggests that if the case is exceptionally intricate, it might be unreasonable to expect adequate preparation within the established timeframes. In addition, this phrase signals that there are additional consideration beyond those outlined in the previous paragraphs. It established that continuance cannot be granted for reasons such as court calendar congestions, lack of diligent preparations by the prosecutor, or failure to secure available witnesses.
Attorney, good day. This is my topic for this video. Rule 119, Section 5. It says time limit following an order for new trial. If the accused to be tried again pursuant to an order of a new trial, the trial shall commence within 30 days from notice of the order, provided that if the period becomes impractical due to unavailability of witness and other factors of the court may extend it but not exceed 180 days from notice of said order for a new trial. Section 11, Circular number 38 to 98. The Section 5, it says, and here's my explanation about Section 5. There is a rule that says if someone is going to have a new trial, it must start within 30 days after they are told about it. But if it's not possible because of problems like not being able to find witness, the court can give them up to 180 days. This rule helps makes your trials happen in a timely manner. For example, if someone accused of a crime and gets a new trial, the court has to start the trial within 30 days after telling them about it. And I think that's all of Section 5 of my discussion. Thank you.
Section 6 of Rule 119 extended the time limit. Notwithstanding the provisions of Section 1, Rule 116 in the preceding Section 1 for the first 12 calendar month period following its effectivity on September 15, 1998, the time limit with respect to the period from the arraignment to the trial imposed by said provision shall 180 days. For the second 12-month period, the time limit shall be 120 days, and for the for the 12-month period, the time limit shall be 80 days. So, this section seems to be from a legal document or statute regarding the time limit for arraignment to trial. it establishes a decreasing time limit over three consecutive 12-month period following its effectivity in 1998. In essence, it's setting deadlines for how quickly a case should move from arraignment to trial within the court system. So let me give you an example. Let's say a law was enacted on September 15, 1998, establishing time limits for cases to move arraignment to trial. For the first 12-month period following the law effectivity, cases must be brought to trial within 180 days from arraignment, approximately 6 months. For the second 12-month period, the time limit decreased 120 days from arraignment, approximately 4 months. And for the 12-month period, the time limit further decreased to 80 days from arraignment, little over 2.5 months. So, if a case was arraigned to September 30, 1998, for the first 12 months up to September 30, 1999, the trial should commence by March 29, 1999, 180 days from the arraignment. For the second 12 months up to September 30, 2000, the trial should commence by January 29, 2000, 120 days from arraignment. And for the third 12 months up to September 30, 2001, the trial should commence by November 29, 2000, 80 days from arraignment. So this example illustrates how the time limits gradually decrease over three consecutive 12 months period. Thank you, ma'am.